Hello, everybody, and welcome to History/Law Bite number 269, dated June 6th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Miranda versus Arizona, 384 U.S. 436, 1966. Miranda versus Arizona is, of course, the landmark U.S. Supreme Court decision that gave us the Miranda Rights. And everyone who has watched any type of show related to the judiciary or police procedure, more specifically, has at least heard the Miranda Rights. You have the right to remain silent. Anything that you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you at no cost. Do you understand these rights as I have read them to you? We've all heard this before, all right, either on TV or perhaps in person if you've ever been arrested and then subject to custodial interrogation, because that is exactly what this case deals with. You know, the admissibility of statements made during custodial interrogation, and thus knowledge of your rights to refuse to talk during a custodial interrogation, either at all or only with your attorney present, okay? So, as we begin a Supreme Court decision here, we begin in the same way the Supreme Court does. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, 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 all persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. So we begin to discuss Miranda versus Arizona. So, Miranda versus Arizona began in spring of 1963 when our petitioner here, Ernesto Miranda, was arrested by the Phoenix Police Department, largely on circumstantial evidence connecting him to a kidnapping and rape several days earlier, all right? Mr. Miranda would be interrogated, probably very harshly, for about 2 straight hours before he signed a written confession to the rape charge, all right? And the confession read as follows: I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights. Understanding any statement I make may be used against me. Okay, cool. The problem with this was Mr. Miranda had not been made aware of any, and I mean any, of his legal rights, okay? Nor was, in all likelihood, he familiar with any of them. Mr. Miranda was not exactly what you would call a first-class citizen, all right? He was fairly uneducated, you know, for all intents and purposes, a guy just trying to make it literally from day to day, all right? Not exactly, you know, very knowledgeable of his civic duties and responsibilities, okay? So why would he know what his constitutional rights were, all right? He was certainly never informed of his Fifth Amendment right against self-incrimination, his Sixth Amendment right to have counsel, okay? And you can guarantee he was never made known that anything he said would be used against him in a court of law, all right? And the police, in all likelihood, as it would be the case then as in now, took full advantage of that, okay? So, at trial, you know, Mr. Miranda's attorneys attempted to have the confession tossed out because they asserted it was not made voluntarily, and they were right. Okay, Mr. Miranda was very much coerced into making this confession, all right? But Keeping in mind the era, this is the early 1960s, the judge said, ha ha ha, nice try, denying his attorney's request, and of course using the confession and the other evidence presented. Miranda was convicted of the rape and kidnapping and sentenced to 20 to 30 years imprisonment for each charge. And these sentences were to run concurrently with one another. All right. So, on appeal to the Supreme Court of Arizona, they affirmed the decision from the trial court, which led him and his attorneys to seek a writ of certiorari to the Supreme Court of the United States. So at the Supreme Court, all right, the justices, the liberal Warren Court at this point, my favorite court, was faced with this issue as follows. Did the Fifth Amendment protection against self-incrimination cover police interrogation of suspects? All right, not a difficult issue per se. And in a landmark 5-4 decision, the court ruled that it did. All right. We have a 5-4 decision in favor of our petitioner, Ernesto Miranda, written by Chief Justice Earl Warren. Okay. The opinion was delivered on June 13th, 1966. Okay. At the time of this recording, nearly 55 years ago. Okay. And Warren's landmark opinion contained the following points. First, that Miranda's interrogation by police was indeed a violation of the Fifth Amendment right against self-incrimination. Next, given the naturally coercive nature of police interrogations, all right, they may be that way now, but they were certainly that way back then, no confessions would be admissible under the Fifth Amendment self-incrimination clause and the Sixth Amendment right to counsel unless suspects were made aware of these rights and had knowingly and voluntarily waived them. Okay? So, in being made aware of those rights, okay, the suspect could voluntarily waive them and talk to police if they so chose. All right? So, if the suspect did not do that, then in all likelihood, whatever they said may well have been thrown out. All right? May well be thrown out, rather. Next, Warren's opinion asserted that a person in custody prior to interrogation had to be informed of his right to remain silent, the right against self-incrimination in the Fifth Amendment to the Constitution, and that anything he says may be used against him in a court of law. The individual also had to be informed that they had the right to consult with an attorney and have that attorney present during the interrogation with the police. And if indigent, one would be appointed for them. All right? So that's pretty much straightforward. All right? The person had to be informed of his right to remain silent. Okay? And anything that he said would be used against him in a court of law. He also had the right to an attorney, and that the attorney could be present during virtually all stages of the interrogation. If they couldn't afford one, one would be appointed for them, okay, if they were indigent. All right. Next, Warren went on to say that if an individual indicates at any time prior, okay, to or during the questioning that they wished to remain silent, then the interrogation had to stop at that point, okay? If an attorney was requested, the interrogation had to stop until the attorney was present, okay? The individual had to be given time to consult with the attorney, all right, confer with him rather. And then the lawyer had the right to be present for any other questioning that was to take place. Okay? So, last but certainly not least, the defendant, of course, reserved the right to waive these rights. Okay? So I don't know why on earth you'd want to do that. But the defendant waived these rights. You had the ability to waive them as long as it was knowingly and intelligently. You had to know what you were doing, okay, after the rights were given to you, all right? And, once the rights were waived, the person could agree to answer the questions and make a statement. And that statement would obviously be admissible, okay? So in sum, folks, evidence gained through interrogation couldn't be used against a defendant at trial, okay? Unless the prosecution showed that the warnings, the Miranda warnings, were given and knowingly and intelligently waived, okay? So they had to show that the defendant had been read their Miranda rights, given their Miranda rights at some point during the process before interrogation, and that the individual had knowingly and intelligently and voluntarily said, you know what, I'm waiving these rights, okay? I don't want these rights. I'm going to fully talk to you, police, okay? Yeah, again, I don't understand, though, why anyone would want to do that, but whatever, to each their own, okay? So, summary of the holding, okay, just to simplify matters, because it was a, pretty detailed decision, was that the Fifth Amendment right against self-incrimination mandates that law enforcement officials, okay, advise a suspect interrogated in custody, all right, of their rights to remain silent and to obtain an attorney, all right, and if they could not afford one would be provided for them at no cost, okay? One more time. The Fifth Amendment right against self-incrimination mandates that law enforcement officials advise a suspect interrogated, okay, in custody before they start interrogating them, all right, before they start interrogating them, of their rights to remain silent, according to the Fifth Amendment, and their ability to obtain an attorney, according to the Sixth Amendment, all right? If they could not afford one would be provided for them at no cost. Okay, so that's the basic holding of Miranda versus Arizona. Okay, before formal interrogation, all right, the police have to, law enforcement of any type, have to advise the suspect of their right to remain silent, okay, and the right to have an attorney. Okay, the Fifth and the Sixth Amendments to the U.S. Constitution. If they couldn't afford an attorney, one would be provided for them. All right? If the person invoked that right to remain silent, that's it. Okay? The Constitution protects their ability to remain silent. All right? If they choose to waive that right and talk to the police, that's on them. All right? But they retain that ability to do that. Okay? Now, not everyone agreed with Chief Justice Warren's opinion. Four justices dissented. Justices Clark, Harlan, White, and Stewart. All right? Justices Clark, Harlan, and White all wrote dissents in this case. All right? Justice Clark, who originally was in the majority, by the way, and decided to switch at the last minute and dissent, okay, moved away from Warren's opinion because he felt that the court had moved too far, too fast. Okay? Justice John Marshall Harlan wrote a dissent, a little bit more biting, asserting that nothing in the letter or spirit of the Constitution supported the decision in Miranda versus Arizona. And Justice Byron White perhaps wrote the most biting dissent in Miranda versus Arizona, asserting that the court had announced a new constitutional right with no factual or textual basis in the Constitution whatsoever or from previous decisions of the court. White's opinion, like I said, was very heavy on the rhetoric, and he said that Warren's opinion would one day return a rapist or a killer to the streets to repeat his crimes, with impunity. And, whenever he feels the need to do so. That there will not be a gain but a loss in human dignity. I think Justice White was being just a tad bit extra with that analysis. I think he was really playing the scare you card, because nothing of the sort has happened according to the levels of the predictors of grim here in Dissent. The Miranda decision has not placed the undue burden on law enforcement as the dissenters here have asserted, that it would in the future. All right. So the judgment of the court essentially reversed the conviction of Ernesto Miranda and remanded his case back to the trial courts in Arizona for him to be retried, which happened, and he was, this time, believe it or not, sentenced to virtually the same thing, very long prison sentence. He was paroled in 1972, and he died as a result of being stabbed several times at a bar fight in January of 1976. All right? But even though Mr. Ernesto Miranda is long gone, the legacy of his case remains strong to this very day. All right? So before police can formally interrogate you, you have to be informed of your rights to remain silent and the right to an attorney. All right? Now, I don't want anybody to interpret this as formal legal advice, because I am not an attorney. And if you have a legal issue or problem, you are required to seek the assistance of an attorney licensed in your jurisdiction. Okay? But I am allowed to point out procedural information, just for the record, for your own personal knowledge and enhancement, that even though you often see it on television, like shows like Law and Order and maybe NYPD Blue, or, lots of, like I said, police procedural dramas, you usually see the Miranda rights, read when someone is arrested, which does happen at times, but not all the time, folks. That is not the way it always happens, okay? And it often doesn't happen while you're sitting in jail, waiting for the next step. Okay, not prison, jail, just being, held, while, your records are being pulled and whatnot. Okay, you will, however, hear these rights before any formal interrogation. All right, or anything that you say, during the course of an interrogation by police or law enforcement officials of whatever kind, and you are not read the rights first, they run the severe risk of getting all the statements thrown out, okay? So in sum, you must be informed of your rights, okay, to remain silent and to have an attorney before any custodial interrogation can begin, all right? That is what the holding in Miranda essentially bestowed upon the country. And the levels of that have, fluctuated depending on the circumstance with time. And by that, I mean, in the past 55 years, which is how long ago Miranda was handed down at the time of this recording, there have been many Supreme Court decisions that have undermined Miranda's core holding, which most recently was affected with the court's decision in Bergwis versus Tompkins in 2010. All right? So, but just to add a little more history to this, I got to add the history. Miranda was a very, very, very unpopular decision when it was handed down by the court 55 years ago this month, okay? And, it, unlike a lot of Supreme Court decisions, which typically just draw criticism from conservatives or from liberals, Miranda drew criticism from both sides of the aisle, the political spectrum, as it were. And, the justices received thousands of letters of condemnation from local politicians, state politicians, and the like, as well as, law enforcement officials strongly criticizing the court's decision for, essentially crippling the efforts of law enforcement and their ability to fight crime and giving the criminals a one-up. Okay, you have to remember this is the 1960s, and this decision, Miranda versus Arizona, was a very radical decision, ladies and gentlemen, very radical decision. All right, this decision is telling police, all right, or any other law enforcement official that before you can formally interrogate someone, you've got to tell them of their right to remain silent and the right to an attorney. If they can't afford one will be provided for them. And if you don't, anything they tell you during the course of that interrogation may end up in the trash and they may walk free, all because you blundered. All right. So this is a very radical thing, folks. And, this is a typical Warren Court decision. One thing about the Warren Court, when they moved, they didn't tread lightly. I mean, they slayed, all right? And they, handed down decisions that had very profound and long-lasting effects on public policy in America, okay? The Warren Court's decisions, even though many of them have been, like I said, significantly limited, in the past 50 plus years since the Warren Court came to an end in 1969, most of the Warren Court's decisions still remain remarkably intact, even with limitations, imposed by subsequent decisions. All right. And Miranda versus Arizona is probably, or I'd go so far as to say, is probably the most well-known decision of the Warren Court era by the average individual, even if they don't have a clue as to what court, the Warren Court, which handed the decision down, if they don't know it's the Warren Court, okay, even if they don't know Warren wrote the opinion, they do know that the Miranda Rights, is the product of a court decision, Miranda versus Arizona, okay? Before Miranda versus Arizona, there was no obligation to do this, okay? And, the Miranda Rights is something that most Americans, if not all Americans, are familiar with, like I said, because they've heard it on TV or they've maybe had the rights read to them. Hey, if the officer is not planning on interrogating you, though, there's no need to read Miranda Rights. This is only to protect you in the event of interrogation of sorts, okay? So if he's planning to interrogate you, asking questions about a particular crime or issue or something of the lot, these rights typically have to be read to you, all right? And I am not a police officer, though I do know more than one. One of my very dear friends is one, and he has certainly educated me a great deal about police procedure, okay? Of which the Miranda Rights certainly among that, all right? But this is something that obviously, perhaps more than many other decisions from the Warren Court, this is one that, can truly resonate with most Americans very closely because, should you ever be arrested and, there's a possibility you may be interrogated by police, you're going to hear these rights. You have the right to remain silent, okay? Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one will be provided to you at no charge. Do you understand these rights as I've read them to you? All right? This is very important, okay? Procedural safeguard, to ensure that, our beloved officers, who do put their lives on the line to protect and serve, and who, we truly do appreciate their service and respect them for their service, to ensure that, they follow the law just as well as they enforce it. All right? And Miranda versus Arizona is a mechanism for protecting the rights of the people, all right, against unjust practices. Okay, the people do have constitutional rights, and thus it became the duty of the law enforcement officials to inform them of their rights against the system, the right to remain silent, and the right to an attorney. If they could not afford one, one would be appointed for them. All right? So, that is the Supreme Court's decision in Miranda versus Arizona, 384 U.S. 436, 1966. Once more, that the Fifth Amendment right against self-incrimination mandates that law enforcement officials advise a suspect, who is to be interrogated in custody before they are interrogated, of their rights to remain silent and to obtain an attorney. If they cannot afford one, one will be provided for them. All right? So that's Miranda versus Arizona. All right? Any questions or controversies, leave them down below and I'll be happy to answer them. If you like this video, gain some knowledge or insight from it, drop me a like. I would appreciate it. And if you've not subscribed to my channel, I invite you to do so now. Your support means more than you will ever know. Hopefully this video helped you understand Miranda, all right? At least as it was handed down way back in 1966, all right? It's one of my favorite decisions of the Warren Court era because it is truly a decision that protects the people against potentially abusive power, by the state, all right? And the abusive authority of the state, all right? It keeps the state in check, all right? And that was one great theme of the Warren Court, to protect the constitutional rights of the people against the power, to say the very least, of the state. So I thank you again for listening. Take care, stay safe out there, and I'll talk to you at the next video. Peace.